So now we're going to talk a little bit about we sort of taken our world out of the estate tax concerns, where the rubber meets the road in so many of our clients, virtually everyone has to deal with this one way or another, is in preserving our assets in the event we need long-term care. And so we're going to talk about, we use the term generically Medicaid planning, because the idea is Medicaid is one federal program that is available to anyone, but with certain strings attached. A knowledgeable elder law attorney can help walk people so that they can become eligible without breaking the law, and most importantly then, without having to spend all their assets till they become poor to qualify for Medicaid. So with that in mind, we're going to take you through the process.
All right.
I'm going to grab a seat because I'm getting a little tired.
So as Rich kind of just said, but I'll go in a little more detail, there are only really 3 ways to pay for long-term care. You can pay out of pocket, so you can just spend 13 grand a month, whatever it is, on a nursing home or even on someone to come in and help out. And even if your level of care isn't that heavy, say 7 grand a month, 8 grand, I mean, it's big numbers. And we don't want to be necessarily going out of pocket for that. If you have long-term care insurance, that's great. Not a lot of people have it. Very few, really, people have long-term care insurance. Only now is it becoming more popular, and it's also becoming more expensive and harder to get. Back when it was affordable, people didn't know about it as much. And there are some people that do have it, and that's great, but again, very, very few people. So that's the second way to pay. Medicare is not a way to pay. Yes?
No, I was just asking you on the long-term care insurance. As part of, say, your advice to clients, do you normally recommend that long-term care insurance?
Well,
or do you look at it?
We're not financial planners or insurance agents, but we certainly recommend having that conversation. Look, financial planning, when it comes to estate planning, financial planning, having an accountant, you do want to have when you're talking about retirement income and long-term care planning, you would want to talk to somebody about it. Long-term care insurance can be a great thing. Like I said, the people that I've worked with that have it, our options are a lot better. Sometimes what would normally be an emergency situation is not such an emergency if there's long-term care insurance to cover some expenses.
So this conversation.
So I can't recommend. I recommend absolutely considering it. Yeah. Yeah. Because it's a tool. It depends on what you need to get built.
If it's not in place, or if it's not an option for someone, that doesn't mean the end of.
No, that's why this is very applicable, because a lot of people just don't have long-term care insurance and aren't going to get it, or would be able to afford it. Because it's just very expensive now. Medicare does not pay for long-term care. It maybe will cover up to 100 days of skilled care, but they can cut you off sooner, and 100 days isn't really long-term, right? And regular health insurance just flat out doesn't cover it. No. So the third option is Medicaid. Medicaid does cover long-term care. The caveat is that you have to qualify for it financially. It's a safety net program. The good news is there is a robust law about it, saying ways that, I'll call it the middle class, can qualify for it. People that have savings, people that aren't below the poverty level. There are things you can do, types of transfers you can make, and ways you can protect your assets. The law allows for it. They permit it. This has been going on. This type of Medicaid planning has been going on for at least 20 years, which is actually relatively new in the legal world, but which makes it kind of fun for us because we can be creative. But here's what we know. So in New York State, we have one of the best states for Medicaid, by the way. We don't have there's a lot of things we can complain about in New York State, but some of those heightened taxes are going to increase Medicaid benefits, which do help out some of my clients. We have a resource limit. So what that means is any kind of countable asset, money in the bank, cash value life insurance, investments, real property that's not your primary residence. Your primary residence is not totally off the table. They just won't deny you Medicaid for having one. Retirement plans, the retirement accounts, the principal of the retirement account doesn't count against this, but the RMDs you take do count against the limits on income. Before I get to income, this is the 2015 limit on resources, $14,850. The 2014 limit was $14,550. Year before that, it was $14,400. Year before that, it was $14,250. Year before that, it was $13,800. The year before that, I was practicing in Philadelphia and South Jersey, so I don't know what it was in New York. Sorry. In New Jersey, the limit's been $2 grand for a long time, and it's not changing. Yeah.
So even New York's number is very low, you know.
I have clients that have lived in North Jersey with family in New York, and I tell them move to New York when it comes to long-term care planning, because getting Medicaid in Jersey is much harder. But as we get to, and so this is going to go up a little bit next year. You know, maybe 150, 200 bucks, something like that. Maybe less, actually, because inflation's so low. But you get the idea. It increases a little bit every year. The income limits. So for community Medicaid, if you're not in a nursing home, there are two types of Medicaid. There's community Medicaid, there's nursing home Medicaid. If you're getting help in the home, or if you're in a certain type of assisted living that accepts Medicaid, the income limit is $825 a month. Now this is also for 2015, it'll go up a little bit next year. That doesn't mean if you make more than that, you totally don't get Medicaid. What that means is if you make more than that, you have to spend the overage on your care, and then Medicaid will pick up the rest. They let you keep $825 a month, and they cover the rest of your expenses. Now, if you're in your home, $825 a month isn't doing you a heck of a lot of good between food and clothing and property taxes and maintenance and everything else, and just general living. There are ways around that. It's called a pooled income trust. We don't really go deep into it here because it only, you know, doesn't super often apply, but we can kind of help you out there. We can avoid that. We can allow you to use all of your income essentially, even if you have community Medicaid. But for someone that's institutionalized, someone that's in a nursing home, the limit is 50 bucks a month. They basically, the logic, if you want to call it that, behind that is that in a nursing home, they're providing everything for you, so you don't need income for anything other than to get your hair done once a month or buy a nice bottle of bourbon, which is what I'm going with if I'm in that situation. If they don't allow me to, I'll hide it in my room. Probably shouldn't have said that on camera, but anyway. Those are the resource limits. And as you can see, they're pretty restrictive, right? I mean, you know, if you've got anything resembling a savings, then you're not going to qualify for Medicaid. And if the nursing home or the DSS has it their way, the DSS is the Department of Social Services, they're the county office that processes Medicaid applications. They're going to want you to spend down all your savings. They're going to want you to pay privately until you're under these limits, and then they'll give you Medicaid. Well, we don't want to do that. Those resources limits I just mentioned, those are for the person applying for Medicaid or receiving Medicaid. If you're married, your spouse also has limits if you're going to be applying for or receiving Medicaid. Again, these are numbers that raise a little bit every year. This year, $119,220 is the amount of essentially money, investments, that sort of thing that the community spouse is allowed to have. The maximum income a community spouse is allowed to have is just under $3,000 a month. The thing about that is that if the community spouse, so, you know, the situation that I'm most often dealing with in, you know, as far as the generation that this is affecting now, is essentially the husband's the breadwinner, and the husband's also the one that needs long-term care sooner, right? The wife maybe makes several $100s or a little over $1,000 in Social Security for income per month, but that's it. What they're allowed to do, the community spouse is allowed to take enough of their institutionalized spouses, the Medicaid spouses' income to hit this almost $3,000 number. So this is sort of like the maximum between the two spouses. But there are cases. The good news is in New York we have something called spousal refusal, which I think Florida has spousal refusal, right? That's it, other than us.
Right.
Where if the community spouse has more than this, and I've seen this, you know, a good handful of times. You do this enough, you see it, where the community spouse has $3-something thousand of income a month or more, and they've got more resources, or we've transferred all the resources to them. They can just say, I hereby refuse to financially contribute to my spouse's cost of care, and they're just allowed to keep their excess resources. It's as simple as that. I will say,
responsible for any payments if you take spousal refusal?
So, usually not, and here's what I mean by that. Spousal refusal just means that they can't deny your spouse's Medicaid application if you have too much money. If this was New Jersey, spouse just doesn't get Medicaid at all. In New York, what happens is they approve the spouse for Medicaid, and then they have the option, they are allowed, the county would basically send you a letter. They have the authority to send you a letter to say, you're over-resourced, we would like you to contribute some of those excess resources toward your spouse's care. And at that point, it's a negotiation process. You know, I've had a couple clients where this has happened, and we get in touch with them, and we get in touch with the county and say, okay, how much, you know, are you looking to get? And we work it out so it's not a burden on the well spouse. They still, you know, they maybe pay a little more for their spouse's care, but they're still keeping the majority of their stuff.
Right?
Well, that's the thing. No. You can't just tell the county to pound sand if they ask you to do that. You got to talk to them, and you got to come to an agreement. If you do, ignore them, then they can sue you under a theory of spousal support, like in family court.
Yeah.
Luckily, I've never been in a case where that's gotten to that point.
But
also doesn't often happen
applies to
anyway.
a disabled person too. In other words, you have a disabled child, or I think the spousal refusal is in on that too. I remember a friend of mine had a problem with that.
If they're a minor, you have an
Yeah, that's what I
obligation
mean,
for it.
yeah.
Yes.
Oh, yes.
Yeah.
Yes,
have
you
a
do.
Obligation to support, yes.
Yeah.
So, yeah, that's, I think, that's kind of, in other words, you're not legal, the spouse is not legally bound to contribute support.
Well, they are legally
That's the thing,
bound,
they
but you
are
can
legally
refuse.
bound, but the way the process goes is that they can initially refuse, their ill spouse gets on Medicaid,
Right.
and the county might get in touch with you to say, listen, you
Okay,
should
so
support a
they are
little bit.
initially legally bound.
Yes.
Yeah.
There is a spousal obligation support which you can reject, essentially.
But with the spousal refusal.
Correct.
Okay.
Right.
What is that called, the spousal obligation support, you said?
Just
Support
spousal support obligation,
obligation.
yeah.
Support
Yeah.
obligation.
Yeah.
All right.
Okay, let's,
Okay.
That doesn't make any, how much money the person has either. It could be a millionaire, right?
correct.
Yeah.
The fact is, though, the more assets you have, excess above the exemption, the more likely you're a target for a support action by the
Yeah,
county.
legally, can they, I guess they can sue you, right?
Yes, they will.
Yep.
Okay.
They can, not that they will.
Legally,
Many counties
not-
have not been active in suing.
yeah.
But not if you pursue the refusal.
Oh, no.
You can't-
No, they'll sue you
All
after the
refusal
fact.
does is allow your spouse to get on Medicaid.
Right.
Even after doing the spousal refusal, they can still ask you to
Yeah.
submit to support your spouse.
Right, but they can't refuse your spouse's Medicaid if they, if the
Oh, okay.
if the ill spouse meets the
Okay.
criteria
Right.
of the asset and income
Oh,
limits.
Right.
So refusal just refers to being able to
Right.
qualify for the Medicaid.
Remember, like I said, in New Jersey,
That's fine, yeah.
your spouse just doesn't get Medicaid at all if you have too much money. In New York, your spouse gets Medicaid, you just have to talk to the county about how much you're going to contribute.
Sure.
All right.
So what happens if you are looking to make gifts? And there are different rules that apply under different circumstances.
So what, you know, the Medicaid laws, they understand, you know, our legislature may not be totally full of geniuses, but they do know that if you say, I'm going to offer a benefit, but you have to have under a certain amount of money, then people are going to try to get rid of their stuff to get on the benefit, right? That's where the look-back period comes in. If you apply for nursing home Medicaid, they ask you to submit to them 5 years of financial records. Bank statements, retirement account statements, investments, tax returns, you name it. They are allowed to ask for it, and if you want to be cute about it and tell them they're not going to get it, they're just going to deny the application. They don't have to grant the application, right? So what they look for when you give them these records is whether you've given stuff away during that time. What they call them is uncompensated, non-exempt transfers. So uncompensated, we realize, is just giving stuff away without getting anything back. You are allowed to buy and sell things, you know, it's uncompensated that they're worried about. And non-exempt means there are some transfers, you can give stuff away to some people, and that's totally exempt, that's fine. Spouse is one of them. You can, unlimited transfers between spouses will not affect anybody's Medicaid eligibility as far as the transfers are concerned. An adult disabled child, you can give all your assets to an adult disabled child and get on Medicaid without having to worry about the 5-year look back. Again, any kind of large transfers, we're going to want to make sure we're doing it in the right way, but these are the laws that are underpinning it.
Right, so one of the most common use of exempt transfers with a husband and wife, husband is the one with ill, they own joint assets. What we do is we'll transfer them solely into the wife's name, get him at below the $14,850 asset limit, Do a spouse refusal, voila. They could have $600,000 in the bank. He'll get Medicaid tomorrow.
Right.
Done. All right? And that's very common. Then we deal with the post-eligibility issues that we just talked about.
Right.
So that's the most common use.
But if there aren't exempt transfers, ways to just get essentially money to a spouse or a adult disabled child, there are a few other really esoteric ones. That,
Minor children, too.
They look for these transfers, and if they see there's been any money given away, money or property, anything of value, again, when I say money, I just mean value, they institute a penalty period. Now, let's be very clear here. You know, it is not illegal to give away money and then apply for Medicaid. It's not. They just disincentivize it. They just say, well, you're going to give away money and apply for Medicaid? Okay, well, guess what? You're asking us to give this to you. We're not going to give it to you for a certain period of time, depending on how much you gave away. So if you gave away $100,000 during the prior 5 years, then they're going to take that $100,000, they're going to divide it by what they say is the average cost of nursing home care in your region per month. Whatever that number they get, it's like 8.4 or something. If it's $100,000 divided by the average cost, the Department of Health says that the average cost of nursing home in this region for 2015 is $11,455. You know, that includes Sullivan and Ulster, so I think that pushes that number down a little bit because around here it's more like 12 or 13. And you can see what it is kind of statewide. It kind of tracks what you'd expect cost of living to be.
Do you have any choice of nursing home you go to?
Well, if you're being, so,
Like
yeah, I
in
mean,
New York
if
State.
you know,
you're private
your
pay.
family, first of all, if you're private paying, and secondly, if you've gotten to the point where you need to go to a nursing home, you sort of do. I'll put it this way, because oftentimes someone goes into a nursing home because there's been some sort of precipitating event, they've fallen or they've had a stroke or something like that. They go to the hospital, and the hospital says, look, you know, mom, dad, they can't, you know, it's not safe for them to go back home, so we need to discharge them to a nursing home. And with the family being involved, and as long as there are beds available at the nursing home, you can usually kind of direct them where you want to go. I've never seen anybody go to a nursing home that's just so far away from their home.
Nursing home, you know, that's
Yeah,
what I mean.
Right.
Exactly.
Well, maybe say the difference between the county one and private.
Right. Well, sometimes there's the differences aren't necessarily you know, what you'd expect them to be. Right.
That's right.
But right. And look, this is again why we always emphasize proactive planning. So your options are as open as they should be.
Right.
Or as you want them to be. So if they institute this penalty period, if you give away $100,000 and all of a sudden you have to go into this nursing home and Medicaid is not going to cover your nursing home care for 8 or 9 months, that means you're racking up a bill of $11,000, $12,000 a month. So you either have to go back essentially and get that money and spend it on your care, if you can do that. If you can't do that, the nursing home is going to sue you because they've got a big bill that's not paid. And they might sue the person you gave the money to as well. Yeah.
Right.
Which is why we emphasize, of course, proactive planning.
Right, and that leads to a more proactive approach. Crisis planning we can do what's called half a loaf plan and preserve. Someone came to us with $400,000 of assets and they're in a nursing home tomorrow. We can save reasonably $200,000 plus of those assets. That still means, though, $200,000 subject to spend down.
Right.
If you
Not
come
great,
to
but it's better than nothing.
If you come to us well,
And that's last minute.
Right. If you come to us, you're 62 years old in pretty good health, or 70 years old in good health, we can fairly confidently save 80 to 90% of your assets. Technically 100%, but that would mean putting everything in a Medicaid trust, which is not what you're going to do. So a proactive approach is to create an irrevocable Medicaid trust. So a Medicaid irrevocable trust is a trust, like the other trust. It's a contractual instrument, but it's a little different in that you can be the trustee of your own trust, but you cannot have access to the principal assets that you put in the trust.
The reason this works, by the way, is notice we're talking about this 5-year look-back period. You have to provide them with 5 years of financial records. So if you gave away $1 million 5 years and 1 day prior to that, legally they can't give you a flack about it. So that's what we talk about when we talk proactive planning. Transferring your assets, holding your assets in such a way at an early enough time where they're not allowed to give you a penalty period.
Right, so funding a trust now will start that 5-year clock running so that well before you ever need long-term care, if you ever do, the assets are out of the 5-year window, the look-back period has expired. And it's clearly a better choice than outright gifts in most cases, first of all, because you can retain significant control, plus that step up in cost basis issue Austin talked about earlier. An outright gift, your kids will take your carryover basis. In a properly structured Medicaid trust, assuming they inherit at the time of your death, they're going to get the step up in cost basis. Right. So this diagram will show you the mechanism of how this thing works. So we have our little bucket again. You're the trust maker. You put your money. Often the most common asset we fund into a Medicaid trust is a house. So this is something you paid 30 years. You finally paid off your mortgage. You got your equity in your house. It's a place to live. It has value, but really you think of it as a place to live, even though it has real economic value. The problem is if you go to a nursing home and you don't have a spouse living there or an adult or disabled child, the Department of Social Services is going to count it as a source of equity. They're going to put a lien on your house, and therefore, while they may cover you for Medicaid, someday the house is sold, they may get all or most of the sale proceeds. So that's a real problem. But if you put a house in a Medicaid trust, you go home at night, the day after you've funded into the trust, you can take out your key, it's still going to work. You're still going to get in your house, but you started that 5-year clock. And that's really important. It's subject to the 5-year look back, so it's going to start that transfer period today. Trustees, in our practice, we don't have any great problem with the client being the trustee. Some attorneys don't have the client. I don't really know why, but in our opinion, actually, so long as the trust has proper restrictive language, it shouldn't put you at any risk. If you do choose other people's trustees, like I had a woman in today, she's 86, wants to have her adult son as trustee, but I told her you can fire him at any time if he doesn't do what you want him to do. Mm-hmm. You're allowed to keep all the income from the trust, because keep in mind, most people doing this are in their retirement years or very close to it. They know what their income is. They got their pension or IRA distributions or 401ks, Social Security, and they want to have their investment income. Many of the people we work with don't even use their investment income. They let it accumulate. But if they want to have it, they can get it. What they can't do is they can't touch the principal. So if you put your $200,000 investment account at whatever, Merrill Lynch or Smith Barney, or there's no Smith Barney, Merrill Lynch, Morgan Stanley, whoever they are anymore, Schwab, Vanguard, you name it, they're all out there. You can't then the next day, even if you're the trustee, if you say, you call up your investment advisor and say, Joe, send me a check for $30,000, then you've sort of blown up the trust. But does that mean you can't really access the principal? Not necessarily, because even though you and your spouse can't receive principal, you can have the trust specify that other people, either a class of beneficiaries or specifically named people, can receive the principal from the trust. Who's the most likely people that's going to be? Children. Yeah, so your kids. Kids or descendants or something else that. So you as trustee can call each of your 3 kids, say, kids, I have good news. I'm gonna being very generous this year. We're gonna write you a check for each for $10,000 out of the trust. That's fine. Then what's shockingly, a month later, you get a note in the mail along with a check from your daughter saying, because you're such great parents, I've decided to give you a gift of $9,500. Right? You never had a conversation with them at the table to say, oh, by the way, we're giving you money. Next month you're going to write us a check. It just happens to fall out of the thin air that you get a gift from your kids. Now, that's not really what's happening, honestly. It can happen that way. But that is a way, as long as it's done in a kosher manner, I think. Because once the money is distributed to the child, it is their money. They have absolutely no legal obligation to do anything with it other than use it for their own benefit. If they choose to give it back to mom or dad, yeah, you're probably okay with that. So the reality is very rarely will anyone actually need that money, but it is good to know from a comfort level that if there is a way to obtain money, should it be necessary. In a very rare case, we need that. If you do sell the house during your lifetime, some people fund the house. One of the questions we get, can I sell the house or can we sell the house? The answer is yes. And as long as you're living in the house within the prior 2 years from the sale, it will still qualify for the capital gains tax exemption that is only available to a homeowner. For single people, it's a $250,000 gain exemption. For couples, it's $500,000. Now, after both your deaths, if it's a married couple, after your death, if you're a single person, so the trust will act like any other trust. It'll pass assets, into shares for child 1 and child 2 or 3 or 4, however many you have. We're going to create those nice lifetime protective trusts. Now, but what if people worry and they say, well, what if I change my mind? You put us into this irrevocable trust, which is legally irrevocable. You can retain a limited power of appointment, which we often refer to as a power to disappoint. All right? Because even though the trust is irrevocable, you can retain the right to change the final disposition and the beneficiaries. So if Johnny here forgets to send you a Mother's Day card, you can call your lawyer and say, I want to cut Johnny out and leave everything to Sally. All right? And you can do that. Simple written statement or revise your will to exercise the power of appointment. The mere fact of having this power, even if it's never exercised, which in most cases it's not. Most people, when they leave it equally to the kids, it stays that way forever. By merely having the power, this is what makes sure that the assets that were poured into the trust are part of your estate. Under the tax law, the income tax rules, if you have a power of appointment exercisable at the time of your death, then those assets are included in your estate and they get the step up in cost basis. That's the beauty of this whole thing. So we get the Medicaid protection during your lifetime, you have the income access, principal to the descendants, and then you have the after-death protective trust planning just like we did in the revocable trust. So some people say, which one do I need? Well, it depends. Some people will need, really, their situation will call for having both revocable and a Medicaid trust. Some will just one or the other. It all depends on the circumstance.